represent us fairly. However, after sitting through entire meetings only for these issues not to be heard because the county attorney failed to show up, or there wasn't a quorum, or the public meeting was canceled after we got here, and to witness how these issues have been bounced back and forth from the county services on February 3rd to Quorum Court, on February 20th to county services on March 3rd, Quorum Court on March 20th, Planning Board on March 27th, and into April and now May, and they were not reviewed. I feel as if you and me and your constituents have been cheated. Our valuable time has been wasted, and our trust has been shattered by whatever shenanigans the county is engaged in. I'm the daughter-in-law of former Springdale Mayor Charles Noble McKinney. He was an exemplary public official, an elected leader. He showed me what was special about Arkansas and what we truly cherish: honesty and integrity. Most of all, he showed me how we respect one another, and I think we deserve better than what we've witnessed here. Don't you?
Thank you, Judge. Ladies and gentlemen, I'm Jim Crouch. I'm an attorney in Springdale. I represent Charles McKinney and Mary McKinney, and this is about item 10, the repeal of 2023-26. I want to make some comments about legal matters, but first I just want to bring this to your attention as a fact. I hope you know this matter has been in court. It's been upstairs in Judge Martin's court, and in December of last year, he upheld the denial of this CUP. So you won. Now, since then, this issue of ADA has come up. Those are the only facts I have time to talk about. I want to talk about some legal issues. Procedurally, I think there's a problem. I think that the Arkansas law requires that you have a public hearing anytime you're going to change the zoning ordinance. And this is a change of the zoning ordinance. Now, I understand that this was sent back to the Planning Commission for the April meeting, but it was tabled there because the county attorney wasn't there. So if you consider this ordinance tonight, you'll be doing it without a public hearing, and I think it'll be invalid on its face. I want to talk briefly about the merits of the ADA claim. Eagle Crest claims, well, we're entitled to this use because it'll be a violation of the ADA claim. That's a slippery slope. Remember that this was not denied because there was a substance abuse facility there. It was denied because of problems with sewage, septic systems, and fire protection. And some of you testify to that under oath. So I think if the county agrees to this ordinance and agrees that the ADA claim can be made and they're entitled to this use they want to, I think then that opens the door to anybody. I can come in here and say, I want a nursing home in that neighborhood. I want a clinic, a physical therapy clinic, or I'm not sure what the politically correct term for it is, but I want a prison for the criminally insane. I dare say that if somebody comes in here and says, I've got this enterprise and I'm disabled and I want it in that neighborhood, then the door is open for that. The law is that you don't have to agree to this use just because it's an ADA claim. You're entitled to consider things like sewage, infrastructure, fire protection. So I request that you deny vote against the repeal of this ordinance. Thank you.
Thank you. Public comments.
Hello. I really do appreciate the effort that all of you are making, and that here I am again, Charles McKinney. I live at 19956 Lakeview Road in regard to the Eagle Crest. Now, Eagle Crest contends that if the ADA law requires us to permit them to be in a single-family district, that they should be treated like a single-family home, and that is not the case. 16 people plus staff and deliveries is a group home, and those have physical characteristics. They're larger, they're more traffic, and their requirements under the Arkansas Fire Code are different. In addition, they have greater need for sewer. They also have deliveries. They have all the things that are normally covered under your conditions to be applied to things that don't quite fit in the single-family zone. We believe that they should still be considered. So although that we must allow them to be in the single-family zone, they have physical characteristics which are different, which need to be evaluated and addressed. It's a very simple request. Just treat it like you live next door, and that you are concerned about the fire protection, and that you are concerned about the septic capacity. And by the way, they've had 2 years to address these issues, and they have not. They've chosen just to pursue the legal route. There needs to be some guarantee that, and we hope that you will help us with this, through whatever manner you choose to address those issues. Thank you very much.
My name is Cecily Duncan. I'm at 16572 East Wyman Road. And tonight, I'm really just here to pray. And I'm going to do that now through song. Sing, little birdie, sing, little birdie. Sing, little birdie, sing, little birdie. Sing, little birdie. Every morning I hymn to the dawning. I hymn to the dawning. Every morning I hymn to the dawning. I hymn to the dawning. Sing, little birdie, sing, little birdie. Sing, little birdie. I'm also here in Requiem for the honeybees. The United States of America this spring suffered the largest beehive collapse in history. This directly impacts our food supply chain. And having worked at our local co-op, I also know from experience that we are currently experiencing failure to source. Not only that, but I have 10 years as a property and casualty insurance sales agent. I left that career in 2019, which means I had access to big data. And I was licensed in all 50 states. And I can tell you that year after year, each year shattered record, one after another. The last year I was in that industry, the record for catastrophic losses was shattered by 4 times. So I'm here for the things that can't speak for themselves, the Bloody Crane spill and the corn speedwell. When I look at these lands, I see God's promise. And I just ask that you consider that when making decisions about the development of the county. Thank you.
Public comments.
Good evening. So my name is John Minotti, and I live at 10991 Borchardt Road in Lincoln, in Washington County, of course. It's my wife, Lisa. So I'm here tonight. Some of you may recognize my name because I've been sending out a couple of emails, and this is concerning the wind turbine project that's being targeted right now in Washington County. So these wind farms are going up in other counties in Arkansas right now, which just really surprises me that overall the state would allow something like that. Now, I'm probably here early, and when I say early, I mean in terms of where this project is. So nobody signed any leases or anything, so nobody has entered into an agreement with the wind farm company that's out there right now, scouting out the area to see where they can put these turbines. So they originally started with a target of 45 wind turbines to go up in Washington County. Now, I'm sitting here talking about this, and I don't know if you can really actually visualize what I'm saying, but if you've ever seen a wind turbine, most people have seen them from their car when they're driving through Iowa or in Texas or some other place. And in your car, you look out there, they're fascinating. They're about that big. You see them off in the distance, and it's fascinating. But you get out of your car and you go closer to these things and you realize how extremely massive and industrial these things are. I mean, they are massive, 700 feet in the air, 3 football fields up in the air. And they're wide. Even though their initial footprint is the pad, the fins that stick out, it just covers just an unbelievable amount of area. We've only lived here for 2 years, and we moved here after doing a lot of research, and the first question that we asked the real estate agent was about wind farms. Do they do them here? She says, no, there's not enough wind in Arkansas. You never have to worry about it. Well, it turns out if you have a 700-foot wind turbine up in the air, the wind is perfect. So the whole area, the whole state of Arkansas is now being targeted for these wind farms in all these counties. They're going up everywhere. And I was just talking earlier to Mr. Dennis, and he was telling me that even if this thing did go forward in any way, shape, or form, we wouldn't see dirt being turned over for it for at least 5 years. So like I say, I'm here probably a little bit early, but I just wanted to start this process. Like I say, I've sent out a couple of emails, and I will send some more just to keep you informed and let you know what kind of information I have about these things. But the last thing you guys want, especially in Washington County, is to turn it into an industrial wind farm, wind turbine park. I mean, the land that they have to use and basically tear up just to lay the lines to go across the property is one thing. And what a lot of people don't realize is they'll come to these people that need money, and I'm out of time. I'm sorry. Okay, thank you.
Well, I need a minute or 2 minutes. Can't
I'll
have
make
both.
I'll make it very quick, sir.
Can you just wrap up? Can we?
Yep,
can we all-
we'll just wrap it up. I just want to say that I will be sending out a couple more emails just to kind of keep you informed of where the project is and how a lot of the people in the area feel about it. But I just wanted to make you aware of it for now. But thank you very much for the time. I
Thank you,
appreciate
sir.
it.
Yep.
Good night, sir.
And we've got about a minute and a half left. If you'll come up here, how much time you want, JP Pawn? Suspend the rules for give her 3 minutes to speak. Second by Justice Lemming. All those in favor? Please, ma'am.
My name is Claudia Henderson, and I live at 19719 Natural Walk Road, Springdale. I'm not very far from above the Eagle Crest deal and all that's going on. They're wanting to put an RV camp in behind me, Genesis Cup. Our roads are not wide enough. We have potholes as big as 5-gallon bucket lids that they did halfway kind of fix, but they're not fixed. The kids have to walk from the church to home. The buses do not pick them up. And them RVs coming around those curves out there are not gonna see children walking from their bus stop to their home. And I'm very concerned about the sewer from this RV park. I'm very concerned about how they're gonna build that RV park with the pads or chat, because you're gonna have wash off from whatever they put in there. And we have wildlife in my backyard. It's gonna mess with it, and I'm not happy about that. If I wanted to live by an RV park, I wouldn't have moved where I moved 40 years ago, and I do not. But I do live above the Eagle Crest thing, and I've not been happy with that either. So, That's what I've got to say.
Thank you. A motion to suspend the rules and add 3 minutes by Justice Pond, second by Justice Lemming. All those in favor? Those opposed? Please proceed.
Okay, thank you. My name is Mary McKinney. I live at 19980 Lakeview Road. I live directly across the street from Eagle Crest. This is close to 3 years now that we have been dealing with this situation. This body and the Planning Commission clearly denied their cup, hands down. Many of you in this room were here, some of the same folks. Not much has changed. The ADA laws and FHA laws haven't changed. County Attorney Lester, at the initial hearings, made no indication of discrimination. When Eagle Crest filed the appeal in district court, my brother and I, Charles, petitioned to intervene. We had opposition from Washington County about intervening, and we were on the same team. We've had zero enforcement of this CUP for 2.5 years, zero enforcement. Now, granted, while there's an appeal, I understand that there can be no enforcement, but there are periods of time where there could have been enforcement and there was zero enforcement. My point here is we've been swimming upstream against an elected official and a staff member. Now, when Eagle Crest and we were in district court, it really appeared we were going to be very successful. And then they threw a Hail Mary, hand-delivered a letter to Judge Deakins on March 19th. For whatever reason, he chose to hold that letter, bring it to the April Quorum Court meeting, and have it added to the agenda. No notice at all given to our neighbors or myself. Now, that was a little suspicious, if you will. Then after my research to find out through his Judge Deakins' LinkedIn page that he was a previous employee of R&P Law Firm as a accounting firm per diem. He was a CEO and manager. Now, there's just more than meets the eye here, and what I want to ask you to do tonight is ask the questions and maybe table. If you're going to vote, we don't know if you're going to vote or not vote. Like I say, it's kind of been a moving target for us. We can't get the clear answers. But there's more than meets the eye here, and I don't want you to rush and make these decisions. Something is not right, and nothing has changed with Eagle Crest except the frequency of the pump truck now coming to pump out their septic. They have never had a test. Yesterday, and Eagle Crest told you, the CEO, John Hernandez, sat right, he used to have a table here, and he said, we don't have lake access, virtually no lake access. Yesterday, I watched them move a boat dock, community dock, into that cove. They have lake access, and I can show you photographs of them swimming in the lake.
Thank you, Ms. McKinney. Your time's
Okay,
expired.
thank you very much.
And with that, we're going to move into the approval of the minutes. The minutes were emailed out with your packet. Do we have any corrections with the minutes? If not, I'll entertain a motion to accept those. A motion to accept by Justice Lyons, second by Justice Dean. All those in favor? Those opposed? The minutes have been accepted. Now we move to the county judge's report. First of all, I always want to thank our Washington County Extension Office. Tonight, the Master Gardeners were here to offer refreshments. We really appreciate that. Thank you so much for all that hospitality. We have included the disposal report in your packet. I would also like to go ahead. We do have some appointments tonight. We have 2 reappointments to the Board of Equalization. That information went out with the packet, and I would entertain a motion to accept those 2 appointments. So moved by Justice Pond, second by Justice Lyons. All those in favor? Those opposed? Those 2 appointments will be accepted. Thank you for your cooperation there. A quick update, coordinating with Chairwoman Ecke, we are going to invite Nick Robbins to the next County Services Committee. He's confirmed that date to give us an overview and overlook of the Community Rebuilding Initiative to this point. I have just a quick update. Here tonight, we are currently on day 17 of that initiative. We've had 14 souls enter that building, and things seem to be going very well. I'll share with you that the first day we opened 3 weeks ago, I was too afraid to text Nick and see how that first day went, just apprehensive. But he said that that day 5 souls came into that building, and that one of them, after a couple hours, said, "I can feel the love." So I think that's where we're headed, and I hope you all can take some pride in that. Just a couple little notes here. We currently have 14 souls in that building. We've had 2 depart the program since its inception. One went to the Community Alternative Program in Huntsville, so he graduated to a larger program, if you will. One left the program voluntarily. He had a position in a residential substance abuse treatment facility, but declined that opportunity. And so we're of the 2 that have left there, that's what we've seen so far, so you can be updated there. We will continue to bring in capacity every week. The plan is to continue to bring in 5 individuals every week until we reach the capacity of 30 to make sure we're operationally doing things well. So good start. We hope to see more of that, and I appreciate all you guys' support. We look forward to seeing Nick's full report to you guys at the County Services Committee meeting. A couple weeks ago, I had the opportunity to coordinate with Congressman Womack's office, and he invited HUD Secretary Scott Turner to our region. That was a very interesting visit. His message to us was that, one, Secretary Turner was very involved in the drafting of the Opportunity Zone legislation at the federal level for the tax credits. And we see a big success story in the Opportunity Zone area with downtown Springdale. I believe downtown Springdale is 4 opportunity zones, and we can see the investment that's gone into that area in just the last 3 or 4 years since that's come around, so we appreciate that. And his message, of course, we continue to hear about housing, and we know that we have a housing crisis in this area, and his message to all local governments at any level was to deregulate, to private-public partnerships, and he shared that he has a development business in the Dallas Metroplex area, and that 30 to 40% of his costs in multifamily construction are compliance with regulation. And so, that's in the Dallas area, but we certainly look at that and review that in our area to make sure that we're doing what we can. And of course, maybe some of those comments are important to you guys as you continue the planning work. He sees over-regulation as being a big deal. I know I thank them every time I'm here, but we have a really great men and women in our road department. For you guys, an update, if you're being asked by constituents, essentially this last month has been cleanup from all the rain we've had. So we've basically had to suspend and delay any new construction that we've had over the last month just to clean up and make sure that we're in good shape moving forward. We have been out on Haberton Road out southeast of Springdale working, and so we did get some new construction in this week. But continue to clean up, and if any of our citizens have road concerns that we haven't addressed yet from this flash flooding that we received, please report that to the road department, and we'll try to get that taken care of. Also want to report, we had one of our tractor mower operators a couple weeks ago was out mowing in between Goshen and Elkins, and when he was mowing, there was a close ground lightning strike to that tractor, and it blew the windows out of the tractor. And so we all responded, of course. And I would like to happy to report that the employee is fine. He was transported to the hospital for monitoring some effects of that close lightning strike. But, just to highlight that I'm just remarkably honored to work around those men and women every day. And then even in their simplest tasks of mowing, they're taking on some real risks out there in the elements. And so I always want to tell everybody we appreciate them. And everything they're doing. And finally today, I want to thank the City of Springdale. They hosted the Law Enforcement Memorial this afternoon at the new City Hall complex there, to honor those who've fallen in this area and law enforcement and their families. And it was a great experience. Perfect weather, and I want to thank the City of Springdale for hosting that. It was just a beautiful ceremony. And with that, we'll move on. Item number 8. Counselor, will you read that by title only?
An ordinance amending the Quorum Court budget for 2025.
Discussions or motions on item number 8? Justice Rios Stafford.
Thank you, Judge. This is, as we heard in the Budget Committee, this is an ordinance to put the county in legal compliance with a court ruling where the county was found due to a former employee to be in violation of the Arkansas Freedom of Information Act. And so I move to pass this ordinance.
I have a motion to pass by Justice Rios Stafford and a second by Justice Lyons. Justice Coger?
Thank you, Judge. Yes, I make a motion, I would like to amend the fourth whereas where it says the CJCC has been dissolved. Actually, the CJCC was established by Ordinance 44 of 2017, and that ordinance has not been repealed, and only an ordinance can repeal an ordinance. So this would read, after my amendment, whereas the CJCC lacks a budget to cover said expenses. So I'm just removing those has been dissolved, and thank you.
I have a motion to amend by Justice Coger. Do I have a second? A second by Rivera Lopez. Sorry, man, I'm real bouncing around tonight. I'm sorry, Justice Rivera Lopez. Any further discussion on that amendment? Justice Dennis, did you discuss the amendment or the main motion, or both? Both, I guess. Yes, Justice Dennis, sorry.
It's coming to the full quorum court this way versus going through committee. Is that proper?
It went through committee.
You're talking about the amendment or the actual ordinance?
Well, the actual ordinance or the amendment? The amendment.
The ordinance went through Finance and Budget, I believe.
Okay, thank you.
All right, back to the motion to amend by Justice Coger, seconded by Justice Rivera Lopez. Justice Lyons?
Thank you, Judge. I see the point. I read it differently, so I don't see there's a difference one way or the other, quite honestly. Basically, the way I interpret that whereas is, as of today, the CJCC's been dissolved, which is a true statement. It has been dissolved as of today. It's gone. It was gone, as you said, what, a couple of years ago? I don't remember what the year you said it was dissolved on, but it's been a couple of years that this been dissolved. Therefore, it has no budget, so we got to put a budget somewhere to pay for the award that was awarded by the court. So I honestly don't see a need to go one way or the other.
Further discussion? Are we ready to vote on the amendment? We have an amendment by Justice Coger and a second by Justice Rivera Lopez. All those in favor? Aye. Those opposed? That amendment fails. Now back to the main motion. We had a motion to pass by Justice Rios Stafford, a second by Justice Lyons. Any further discussion on this item? Any public comments on item number 8.1? Seeing none, Mr. Allen, will you please call the roll?
Justice Ecke? No. Justice Dean? Yes. Justice Washington? Yes. Justice Coger? Abstain. Justice Dennis? No. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Bruns? Yes. Justice Wilson? Yes. Justice Massengill? Yes. Justice Rivera Lopez? Yes. Justice Lyons? Yes.
Item number 8.1 passes. Item number 9, Counselor, will you read that by title only?
An ordinance amending the county attorney budget for 2025.
Motions or discussions on item 9.1? Justice Bruns?
Yes, a couple of things that I'd like to ask is, on this $100,000 lawsuit, what was that for? Because I wasn't here when that.
The original $100,000 was allocated for the federal lawsuit from the Arkansas Justice Reform Coalition against the county for the use of its ARPA funds.
Okay.
What we've asked to do, this $38,142.50 represents the remainder of that original allocation, which we would normally just return at the end of the year through the budget process. You know, if it just ends with it'll sweep back. But what we decided to do is be proactive and ask you, ladies and gentlemen, to just reallocate that remaining money to fight the new lawsuit that Arkansas Justice Reform Coalition's brought.
Have we, since we won that first lawsuit, did we ask for any fees? to
We
be-
did not. We were advised not to ask for attorney's fees.
Who advised you that?
Would you like to answer? I'm gonna cue it. I'm sorry. Go ahead.
In order to get attorney's fees, there's some very specific things that have to have happened. And one thing is the court would have had to have found that the lawsuit was frivolous. And the court did not go that far as to say in its order that the lawsuit was frivolous. And as such, we were not really able to get fees because of that. I think what you all, ladies and gentlemen, are gonna learn, and it's a hard pill to swallow, it's very easy for people to get money from you. It's not very easy for the county to get its money back in legal expenses in litigation.
Okay,
It's just the way it is. But the judge did not find that it was frivolous and unwarranted. He made some rulings that indicated that he had some severe questions about the relevance of the lawsuit, but didn't take it far enough for us to ask for attorney's fees.
Okay, but we didn't even ask.
Right, well, there's certain things have to happen to give you that right, and yes, we did not ask.
Okay. Okay. Now, the way I read this is that there's not been any expenses yet on this lawsuit that is upcoming. Is that correct?
That's correct, because we were recently served with this lawsuit. So we
Okay.
have 30 days to file a response. And so we just got served last week, I think, with the lawsuit.
I don't understand why we just don't leave it in unreserved until we find out what we need instead of taking this amount of money and basically broadcasting to everybody, we got $38,000.
Well, we won't find out what we need until the work's done, and then you have billing and you're required to pay your bills. And it would hinder that by saying we'd have to come back to the quorum court every time to ask to pay a bill for legal expenses that we've incurred.
And I think
so-
that's part of our duty.
Okay.
I would rather see you bring something to me saying, we gotta pay this, than carte blanche. And just give it away. I mean, that's my thought.
Yeah, I mean, I hope you can understand that that's fine for us, sitting in this chair, but I haven't found attorneys that like to work that way.
Well, are we going to hire an outside attorney for this?
Yes, sir,
Why?
because our attorneys are now conflicted.
I'm sorry?
They're conflicted, in my mind.
They're
The civil
conflicted.
attorneys at the county, Justice Bruns, are here to represent the entire county. And so what happens in this situation, which makes it incredibly difficult, it was with Justice Coger being so closely associated with that organization. Now we see we have the quorum court and essentially the judge's office in opposition to one another. Our county attorneys, you can understand,
I
that puts
can-
them in
I
almost
can-
an impossible.
I can yield at that point.
Yeah, gotcha.
Yeah.
And it's, I would like to have the freedom to hire outside counsel with this amount of money. And what I'm saying is, like, you understand, we will review the billings, we have payables, accounts payable that go through all that. But what I can understand is we have to engage a law firm to do this. We have to get them started on that. And I
I
think that
really
really inhibits us to say, hey, we'd like to get you started. It might be 60 days before we can even get you a payment, and then we don't know how long it would take to finalize the bill.
I appreciate that. As many times as I've been sued, I can tell you I'm familiar with the process. But the thing I would like to see as somebody who has a vote, one vote, in appropriating this money is that if we're going to hire somebody outside, that we get the approval of this group.
You're talking about the approved who we hire?
No, that we just, I don't care who we hire. I mean, we'd leave that up to the experts, but.
Well, I mean, all I can offer you tonight is that we believe we need this amount of funding. We're going to be extremely responsible with it. It has several checks and balances in it. We don't know how much this is gonna cost. We've been told by our attorneys, we're very realistically gonna come back for you for more, to have additional funds for this lawsuit.
Well, I'm sure we might, but I'd hate to put that out there and then have somebody also bill us $38,000 and do $2 worth of
And
work.
those concerns you're highlighting are concerns of ours too, but unfortunately, it's just the public domain in which we work.
Okay.
Justice Lemming, I believe I cued your microphone by mistake a while ago. I want everybody to know, this system tries to keep track of when you cue in. I'm trying to, recognize people in order, and I'm sorry, I believe I cued your mic, and I think you might have turned it back off, but if you want your spot back, I'm sorry about that. Justice Lyons?
Thank you, Judge. I'd like to make one small correction to the explanation of this that you made, and I respectfully. My understanding that 38,000 was left over from last year, so it's already been swept back into the general fund. And what we're doing is taking it out of the general fund to put it back into his budget. Again, just
Thank you,
trying
sir.
to make for clarity.
I
I've
hope
already
you-
been through this once, okay?
Well, okay, gotcha, yeah. These years blur together. So, no, hope you
I got the
understand
advantage,
nothing.
and I went through this last Tuesday.
Nothing
so-
nefarious in that explanation I was trying to give.
No, I understand.
Right.
But again, just so we're clear across the board for everyone. And I think we've got to put this in there. We've got to trust the county attorney, et cetera, to manage this and manage who we hire to make sure that we're just not getting billed for things we're not doing. I trust that they will do that. We all do that. I mean, everybody, all of our elected officials do that. I mean, we can't ask our elected officials and our department heads to come to us with bills as they have bills. There's almost no vendor that works that way, and we just won't have vendors. So I think we need to do this. We need to put it out there. I think the biggest point that was made, I wanted to make sure was made, is this is just a start. I fully expect we're going to see another one come in as we get close to expending all this to get through this lawsuit. So more's going to come. And I think we just need, I will vote to pass this to get us the representation we need in this lawsuit to win it.
Justice Lyons, may I remind you, we haven't had a motion on this item yet.
Oh, you haven't?
We have not had a
Well,
motion.
then I move that we pass.
I have a motion to pass by Justice Lyons and a second by Justice Dean. Further discussion, Justice Ecke.
Thank you, Judge. For clarification and transparency, can you identify the individuals associated with the AJRC and who is the AJRC that they're bringing this lawsuit against the CRI? What exactly is their accusation against the CRI?
Counselor Lester?
So the lawsuit was brought by Sarah Moore as the executive director of the Arkansas Justice Reform Coalition and by the coalition itself. Their accusation, twofold. One, they're claiming an illegal exaction that the county has received money from the state and is spending it in excess to that which the federal law allows. I won't get into it much more than that, but that's one of them. The other accusation is that this wasn't properly bid and that the sole source that the county did was improper. So those are the two main allegations, or the two allegations that they make.
What is the amount that they're suing the county for?
Off the top of my head, I couldn't tell you that. It was a $300,000 and something grant from the state. And I believe the allegation is that the maximum allowed limit to spend on this project would have been $250,000. And so I'm not real sure what that's what I remember of it. I really couldn't speak to the rest of that question.
I want everybody to know that this is taxpayers' money. This is property taxes that the county collects. And every lawsuit that's brought against the county is brought against all of my neighbors and friends that live in my district and in your district's colleagues. And this group seems to always want to sue the county any way they can on little technicalities. And I think it's sad that they would do that, and I think it's about time everybody knows exactly what this group does. It's all about lining their own pockets. It's all about changing things, and I won't veer off into any of that. I apologize for getting off point, but the way I see it, they're trying to steal money once again from every property taxpayer in this county, and I just don't think that is right. And it's about time somebody shouts it from the rooftop and lets everybody know exactly what they're doing. They're stealing your tax money. Thank you.
Justice Rio Stafford?
Thank you, Judge. My opinion is that the less that is said about pending legislation, the better, because I can almost guarantee some of the things that just get said might be used in the lawsuit itself. But I just wanted to speak up and explain my vote, because I voted in favor of appropriating money for the CRI when it came before this body. And so I feel like that it is the responsible thing for me to do to vote in favor. And there were no red flags at the time brought up about our vote. And so I feel it's the responsible thing for me to do to allow the county to defend a vote that I made, among others. So that is why I'm going to be voting yes on this. Thank you.
All right, we're back to the main motion. We had a motion to pass by Justice Lyons, a second by Justice Dean. Any further discussion on this item? Any public comments on item number 9.1? Seeing none, Mr. Allen, will you please call roll? This is a motion to pass item 9.1.
Justice Ecke? Yes. Justice Dean? Yes. Justice Washington? Yes. Justice Koger? Abstain. Justice Dennis? Yes. Justice Hires? Yes. Justice Rio Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Bruns? Yes. Justice Wilson? Yes. Justice Massengill? Yes. Justice Rivera Lopez? Yes. Justice Lyons? Yes.
Item number 9.1 passes. Item number 10.1, Counselor, will you read that by title only?
Item 10 is an ordinance repealing ordinance 2023-26.
I guess, do you want to introduce this?
Sure. Let me talk about this one a little bit.
Counselor would like to introduce this one, if that's okay with justices before they speak. Counselor?
So, yeah, this, I'm going to kind of hit on some things Mr. Crouch said. The court, in this case, this is the Eagle Crest matter, what the court actually found was that the county did not follow the proper process. The court found that by repealing this ordinance, it was amending and changing the zoning law in Washington County. Again, my opinion aside, that's what the court found. And so the court basically struck it down and said that it wasn't, when you did it the first time, it wasn't done properly. So we're back trying to do that properly and follow the proper procedures. The proper procedure in that is that if this court has an amendment or a change to the zoning laws and the planning laws, that it be set for a public hearing. And I know that at the last meeting of the county services, I was not able to attend. My son's kindergarten graduation was that night. There was some confusion. But I want to address what a public hearing is, because I think there was some confusion around what a public hearing is. A public hearing is defined as a formal meeting held pursuant to the laws or regulations administered by a commission or department for the purpose of receiving the on-the-record oral or written comments from the public on a permitting decision or a rule-making process. That is all a public hearing is. The law, Arkansas law, requires in these proceedings that when a quorum court initiates this, that it be sent to the planning board for a public hearing. It is for public input, just like what you have at every one of your quorum court meetings. It's not a question and answer. It's not a back and forth. It is just to receive on the record public comment. Now, I went back and watched that meeting because I knew it was contentious and I'd heard about it. And so I went back and watched the meeting. I think there was some confusion on the part of the planning board about what was going on. I don't think that it was tabled. I don't think that ever was voted on, but certainly there was some comments made by the chair that this matter would come back up, would have to be heard again by the planning department. And so, when we look at this, I always look at what's the easiest thing to do to ensure that we're not going to be faced with a lawsuit. And so I'm of the opinion tonight that the best course of action for this matter would be for this body to send it back to the planning commission. We will publish in the paper once again, because we're required. Every time we do this, I put an ad in the paper that notifies the public, because that's what the law requires. There's some language about posting that out in a newspaper with general circulation within the county, and so that's what we've done. And so, in order to not face that as a legal challenge, I think it may be the best option for this body to refer that back. I will be at that meeting. It will not be a question and answer with me, but I will certainly be there to hear the public comment. There's nothing in the law that requires that I be there at all. So this idea that I wasn't there and therefore it didn't happen properly is not correct. But I will admit that there was some confusion for the people in the room. And I do not want people to think that they did not have the ability to say all that they want to say with regards to this. And so, it's up to you as to whether or not you move forward with this tonight, or if you send it back and we take a third stab at this. So that's kind of where we are on it.
Justice Lyons?
Thank you, Judge. Counselor, I want to address a couple other things, and I want you to either tell me I'm right or tell me I'm wrong, because I think it's the basis of a lot of the discussion going on. We heard several comments about the CUP process, what it is, what's expected, et cetera. And I think some of those were wrong or incorrect. We do address septic, fire, et cetera, as conditions, but we address it from the point of view of those that are responsible for upholding those rules. Septic is the responsibility of the health department. Fire is the responsibility of the fire marshal, et cetera. It's not the county responsibility, although we do put conditions in our CUPs that says you will meet the fire code, you will meet the health department code, blah, 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 blah. What the CUP process really is, when it comes to the quorum court especially, is about zoning. It's about taking a parcel that may be zoned for one area, single family residential as an example, and voting to rezone that parcel to be commercial, so somebody can do commercial business. My understanding of the argument of Eagle Crest of the discrimination is because we required them to get a CUP, to do a CUP in the first place. And the reason for that is if you have 5 college students living out in Washington County in a single house, we don't require them to go get a CUP.
That's correct.
Eagle Crest, I believe, their argument is, based on their status, they're allowed to be in a single-family residential area and operate based on the ordinances. And because we have nothing that separates number of people or anything else, we required them to get a CUP while not requiring 5 college students to go get a CUP. Is that correct?
That's correct.
Okay. And I think that's important because it's not about, I mean, I understand the concerns of the community with the septic system and the fire and other things. I understand those concerns. That's not the CUP process. That's not the county. And I encourage you to go to the right organizations because it needs to be addressed, and I agree with you. So the health department needs to be contacted on septic. The fire marshal needs to be contacted on the fire. I know it's been 3 years and they haven't done crap that they had agreed to in the CUP process that they lost. But again, that is not the process that we have here. And we need to get it to the right organization to get it resolved, in my opinion. And again, trying to baseline that because of the number of conversations and things I'm hearing to try to get a transparent basis for why your advice is we did discriminate, and that's why, and why you're recommending we repeal the ordinance based on that lawsuit.
So Eagle Crest was initially informed that they did not need a conditional use permit because it was a residential, it was residential. And that was the directive they were given from our planning team. There became an issue about the fire suppression system at that house and what it needed to be, and it got contentious. And so we went out to look at it, and at that point it occurred to us that this wasn't a single family. These were going to be non-related individuals at this place. And that was the reason why they were told they had to get a conditional use permit. After reviewing, myself and Ms. Baker, after reviewing the ADA and HUD guidelines, we recognized that we here in Washington County had an issue, putting us behind the 8 ball for all intent and purposes. It had nothing to do with anything other than these individuals, because of their disability, have to be treated equally as a family in this setting. We don't have a rule in Washington County that says we limit the number of unrelated people for the purposes of living in a single house and it continuing to be residential. I know the city of Fayetteville does have one of those. It went into effect when I was in college because it affected some friends of mine who all rented in a house. They said 4, this was a 5-person house. And so one of them had to move out in order to be in compliance with the ordinance. So those things are common. You see those. Washington County at the moment, we just don't have that. And so with all due respect to what Ms. McKinney said, we are not on the same side. The reason for that is if we are found to be in violation of the federal law, it's not Ms. McKinney or Mr. McKinney or their attorneys that get to pay the fine for that. It is Washington County that gets to pay those fines. It is the taxpayers. It is every taxpayer in the county that gets to pay those fines. I don't have a dog in this fight. I don't live in this neighborhood. I'm not near it. It really isn't personal. It's a matter of making sure that we as the county don't get crossways and the federal court come in and levy fines against us for violating those 2 big federal acts. And so that's my position. As far as the sewer and the fire is concerned with any project, those are state laws. We cannot mandate around those state laws. I mean, those are in effect whether we say they're in effect or not. For us to say you have to follow the fire code is no different than us not saying anything at all, because it's like telling someone, hey, you have to follow the speed limit when you drive. Well, it doesn't matter if I told you that or not, you got to follow the speed limit. Right. That's the law. And so we often remind people that they need to make sure they're compliant to help them out. But again, that's not something that we have any enforcement ability over. And so we don't have the ability to enforce. I can tell you that we've had concerns with compliance issues with state fire code, that we've had grave concerns. And we've had fire departments come and tell us they have grave concerns about what's going on. And all we can do is call the state fire marshal's office and ask them to go out and write a ticket. I mean, that's what they have the ability to enforce those rules. We, as the county, do not. Right. And so that's kind of where we are on this issue. And I think it's important that we know that, it's not as cut and dry as it may seem. I understand that the neighbors have their position and they're entitled to that. And their attorneys are great attorneys that are looking at their client's best interests. But they're not my clients. You all, this county is my client, right? So I have to look after its best interest. And sometimes it may not align with what others out there may think is the best interest because we're held to a different set of standards. And there's certain things that we have to do that others don't. So that's kind of where we are on this.
Thank you, Counselor. Appreciate it. And I hope that helps because, again, my intent in all that is transparency, make sure we're all on the same basis as to why the recommendations out there and why this is coming through. With that, Judge, because we've been a little challenged on this, trying to get this through the planning, between, I think it was mentioned earlier, multiple meetings of not having quorum for the planning board and other things. And I think because, I agree with the counselor, because the chair indicated that it should come back and have that public meeting, I move that we send this back to the planning board for a public meeting.
I have a motion to refer this to the planning board by Justice Lyons and a second by, I believe, Justice Rios Stafford. Okay, motion by Justice Lyons, second by Rios Stafford. Any further discussion? Justice Cogar?
Thank you, Judge. Yes, I would like to make an amendment to this, to this ordinance, starting on line 18, where it ends with the word permit. I would like to add some conditions. Number one, that Eagle Crest Recovery shall obtain a certificate or permit that the property's septic system complies with regulations of the Arkansas Department of Health so as to ensure that the soil is suitable for a septic system for this commercial facility and does not contribute a danger to public health or groundwater. If the septic system does not comply with the regulations of the Arkansas Department of Health, the facility shall take steps, whatever steps are necessary, to bring the septic into compliance and obtain said certificate or permit. B, shall provide exterior lighting that is appropriately shielded and directed to prevent glare, light spillover, or any other illumination that interferes with the surrounding property owner's peaceful enjoyment of their property. All lighting shall be installed and maintained in a manner that minimizes disruption to adjacent properties, ensuring residential privacy, preserving night sky visibility, and upholding the character of the surrounding area. C, shall ensure that all delivery vehicles accessing the property do so without blocking unlicensed roads, private driveways, or otherwise interfere with the public's use of right-of-way. Deliveries must be scheduled and managed in a manner that maintains clear and unobstructed access for neighboring residents, emergency vehicles, and general traffic at all times. The applicant is responsible, it should say Eagle Crest is responsible for coordinating with delivery services to relieve congestion and maintain safe and continuous flow of vehicle and pedestrian movement in the vicinity. And item D would be shall comply with all applicable provisions of the Arkansas State Fire Code, including but not limited to fire prevention, safety measures, and emergency access requirements for all facilities of its nature. And that amendment would also mean that Article 2 would need to be amended to read that right before it, where it says Eagle Crest, it would say that subject to the above conditions, Eagle Crest Recovery shall be allowed to operate without the requirement of a conditional use permit. Thank you very much.
I have a motion to amend by Justice Coger. Do I have a second? I have a second by Justice Hires. Any discussion upon the amendment by the group? Justice Bruns?
Thank you, Judge. With all due respect, I think if we're going to send this back, we send it back like it is, and they can change it. They can have an opportunity to change it at the Planning Commission and then work its way back up. I don't think this is the time or the place to change it.
So I think that with this public hearing, because this initiates here, they can make recommendations to the Quorum Court, but they can't make changes without your permission. Does that make sense? They can certainly vote to request or to say, hey, we think you should do this, that, or the other, but when it comes back here, it'll be up to you. And so
it'll come back here written, Mr. Lester.
But it won't come back with changes. It'll only come back with recommendations for changes. And so
Okay.
you could amend it at this point before you send it down if you wanted to.
Justice Massengill, I'm sorry, I think I killed your mic, but you're in. Go ahead if you want to. Justice Massengill?
Yeah, so we've got an ordinance that says should not have had to apply for a conditional use permit, and we want to add a bunch of conditions for use onto that ordinance. So I agree with Brad that this should be a planning commission recommendation. And I do have a question though. If we send this back to planning, will planning if they make a recommendation, will they be voting on that recommendation and approving it before it comes to us, or do we need to specify that in our?
So the public hearing doesn't require that they make any changes, but if they wanted to, if the planning board wanted to, after the public hearing, vote to recommend changes, they certainly could vote to do that.
Okay, I mean, that would be my preference, that the planning commission, votes on their recommendation before it comes back to us. That's all I had.
Justice Lemming?
Thank you, Chair. Can we have Sam come up for just a second? Back when this all started, I think all this was already asked to be looked at, talked about, wasn't it? On Eagle Crest?
Which, yes, I
When
mean,
you
like,
got the CUP.
we haven't changed anything since like 2006.
I know, but the health department was brought up.
Yes.
The fire marshal, all this stuff in here that's been talked about has already been done.
Yes, our requirement for a conditional use permit is like to get a perk test that says like this property perks, and after that you go and get like the design from the health department and they follow through.
Because that was one of the main issues I got into them with, was about the sprinkler system they was trying to use was not adequate to what they was trying to build.
Yep.
And so I know that's been handled, so I think most of this has already been took care of.
Well, they should have.
It should have.
Yep.
Okay. Thank you.
Justice Lyons?
Thank you, Judge. I got two questions. Just follow on my colleague, J.P. Lemming. Did you say this should have been cleared or taken care of? Was that your last statement? What was your last statement? Well, you said all this was in the cup, this should all been taken care of?
I
Was that-
asked him if all this was in the cup.
Right.
And what I remember, which has been a long time ago, that the health department had to be involved in the septic system because of the amount of people. And the lighting was brought up back then. And I know the fire marshal stuff, the state fire code and all the sprinkler system was brought up because I brought it up.
No, I agree. It was all in the cup,
So,
but we denied the cup. So
Right.
we never did anything, so there was no enforcement, right? There should have been. The fire marshal should have stood enforcement. That's my problem with this, right? One is the fire marshal is the enforcing agency for the sprinkler system. That's where you gotta go to get that resolved. The septic tank is the responsibility of the health department. That's where you need to go to get that resolved. I question the legal ability, Counselor, of putting this into an ordinance that says you don't need a cup, but you gotta meet all these conditions that would be in a cup. And I just don't, I question the legality of that or even the enforceability of that from a county standpoint.
Yeah, I don't know how you enforce conditions if you're saying you don't need a conditional use permit, because that's the whole purpose of the permit, is to have the conditions.
Okay. And that's my concern. I think it clouds the points. Again, I made the points earlier to try to clarify that, yeah, we say you gotta follow fire code, you gotta follow health department, but those two departments are the authority to make the rules and enforce it, not the county, right? I mean, if you come to the county, pretty much, if you come to us and say, hey, they never did the sprinkler system, we're just gonna call the fire marshal.
Well, you
We're
also
not gonna
have
go
to,
try and enforce that,
I mean,
right?
I would also say that if you are now putting conditions on this already federally protected program, you're really running the risk of treating them differently
okay.
than those that don't.
So again, to my constituents, because this is my district, I get it. I understand. You guys know I do. I spent some time with you. We've had a lot of discussions. I just can't support something that I don't think we can enforce, and it's just going to open this up to continue to go down the path and possibly cost us additional fines and fees and whatnot. So I can't support this amendment at this point, and highly encourage everyone to reach out to the appropriate agencies that have the enforcement ability upon that. They're licensed too. I mean, maybe I shouldn't say this, but we all know they're licensed, and their license requires them to follow certain codes, fire code for one, right? So there's another agency that, again, because I know darn well your concern is about the safety of everybody. Without these sprinkler systems, you got 20 people in a house, and if it catches on fire, you're going to have a lot of injuries and deaths. So I know where people's coming from. This is about safety, about the safety of the community with the septic system, the safety of our drinking water, which is Beaver Lake, right? The community has all the right intentions, but we've got to make sure we're utilizing the appropriate process that doesn't put the county at risk for lawsuits and fees and fines and payments, and that something that will give you some legitimate expectation that something might be done. Because I don't think this gives you, I mean, we can't enforce this. If we pass this, we're giving you no legitimate expectation that this will happen because we can't enforce it. So hopefully you guys understand my position.
Wait,
Yeah, so hopefully you guys understand my position and that I can't support this amendment.
Justice Rios Stafford?
Thank you, Judge. I appreciate J.P. Koger's work on this and writing all this up, but I have some concerns about it, maybe some questions for the county attorney if he has a copy of this. My first question is on numbers A and number D, which talk about complying with the Arkansas Department of Health, and in D, complying with Arkansas State Fire Code. Regardless of whether we pass this amendment or not, would this facility still be responsible for applying, for complying with, all state regulations, and anything else that is required with its license?
That's correct. That regardless of if you put this in or not, the law's still the law and they have to comply with it.
Okay, great. Okay. And then on sections B and C, they deal with lighting and delivery vehicles. And I know that was, I think that was, part of our, correct me if I'm wrong, I think lighting was part of our CUP, which is the part of this whole, lawsuit that federal law says we can't have a CUP that requires things like this. Is there some other entity, the state, the federal government, that regulates the lighting and the delivery vehicles and things like that for these kind of permits? I know that you may not know the answer, but
No, and I will say that it's not whether or not they should have a CUP. The question is, is this group of people that are fit within the category of disabilities, are they being treated differently than people that don't have a disability? And that's what the crux of the argument is.
Okay.
Right? And so in putting conditions on a residence, if we're saying that we're not going to treat them differently, sure looks like we're treating them differently, because we don't tell any other landowner out in the county what kind of lights they can have on their house or what time FedEx or anybody can show up. And I know it's not completely apples to apples, but under the federal law, these individuals with a classified disability are to be treated as though they're apples to apples. That's the issue I have as the attorney for the county is, are we going down a path that shows that we are treating them disproportionate to those that, to those like them or to other people without disabilities? It's like telling, it's like saying if you are going to come in the courthouse with a wheelchair, then you have to have certain things that we don't require people without wheelchairs. We would get sued really fast and lose really hard if we did something like that. And that's my fear. It has nothing to do with the McKinneys or the neighbors or anything. It has to do with the liability that the county could face should a court find that is correct.
okay. Thank you. Those are my questions regarding this amendment.
Justice Rivera Lopez?
Council Lester, so if I understand this correctly, from what I've been hearing from discussions, this is really a matter of what constitutes a single-family house. And because there is no stipulation saying that, these people have to be related for it to constitute, a single-family house, if we were to, at some point, propose an ordinance that said that these people in order for it to qualify as a single-use house, that they needed to be no more than 2 people to a room and that were related or something like that, and that's, again, not anything I'm proposing at this moment, would that affect how something like this would have to look moving forward?
Absolutely. If we had a rule that said only a limited number of people that are unrelated can live together up to a certain number to be considered a single family, and it was below the number that they have, or anybody else for that matter, with whether it's residential or not, then absolutely that changes the game completely.
Yeah. So there's obviously ways to go about this, as we just heard. Perhaps this isn't the method to go about it, but there is definitely recourse that we could seek if we do not agree with this. But as our laws stand currently, there's just no recourse for us right now. Right?
I believe it's an uphill fight for us, yes. I think we're on the losing end. That's
Okay.
just my thought. I'm not the judge, but
Thank you.
I can certainly see where a court would rule, and
Mhm.
I couldn't really argue a lot against it.
I appreciate that, counsel. Thank you.
Justice Bruns?
Two questions, just because I don't have the experience y'all have had when this came up. On the septic and the fire, is there a document that they have to provide to us saying that they passed?
No. We don't issue building permits, never
Well,
have.
I'm not worried about issuing anything.
Well, typically
I'm
when you-
asking, are we just getting copies of their septic and from the health department, or are we getting copies from their fire marshal saying everything's good?
No, we don't keep copies of anything like that.
Okay. So I guess you would know if it's expired or not.
No, I don't. I don't have any idea.
Justice Lemming?
Ryan, you mentioned there a while ago the handicap. Are we looking at the people that's in there, or are we looking at the people that own the facility?
We're looking at the occupants, the people that are in there.
So that looks to me like that would be different than if the people owning the facility, we was discriminating against them and they was handicapped, would be different. But they have to have the rules and regulations of their facility to match what they're doing. Is that correct? Because we have to have this courthouse prepared for handicapped folks, just like we can't change that.
Right. The guidance that has been issued by HUD and ADA specifically address the occupants and how they are treated. It's not about the people that own it.
Yeah, but we're not treating them anyway. We're treating the facility that's building the facility.
That's not the way the federal law looks at it.
But that's the way we look. That's the way I look
Sure.
at it. I mean,
Sure.
that may not be right, but to me, I would think that's the right way to look at it.
Right, and you have to understand that the federal law doesn't look at it that way because that would shield people who have facilities from any kind of liability to comply with those standards and say, well, but the handicapped person coming in this courthouse doesn't work here, doesn't live here, therefore we don't have to make the courthouse accessible to them. Well, that's not the way the law looks at it.
We're open to the public, so we have to.
Correct. And when we treat people in settings like this, we have to look at the individuals involved and not necessarily the umbrella that's overseeing the facility.
Correct. Thank you.
Justice Pond?
Yeah, Brian, I want to make sure I'm not confused on this, but this is a residential neighborhood, and this is a single-family residential building, but they're using it for something commercial because they make money by having these people come in there for a week or a weekend or whatever. But because they are under the disabilities criteria, we don't really have any position or any way we can consider them anything besides a single family, is that correct?
Yes, because in Washington County, we have one zone. We don't have zoning, or we don't have traditional multi-zoning. We have one zone, single-family agricultural. That's the only zone we have.
And, I mean, if it was the other way around, if we could look at this as a, you know, these people are gonna, they're doing this thing and it's a commercial business, which it is. They're keeping people there and they're making money for keeping people there. Normally, if we had some kind of business come in, well, let's say it's a wedding venue. And we we looked it over and we heard the concerns of the neighborhood, and we might have a motion to pass. And part of the thing that part of the conditions that we would have would be, we move to pass this as long as the health department is in approval of this many people using this facility, this many people a day or this many people a month or a week. As long as the health department approved, they got a sewer capacity for that many people and this much use. We've even had times where, well, where it was a wedding venue where the people decide, well, we're just gonna only do one wedding per weekend. And we're not gonna be able to meet the needs of more people than that. You understand what I'm saying?
Yeah, yes.
But we can't do that with this, even though it is, you know, they're doing this for money. We can't vote to approve it with these conditions. They gotta meet the health department requirements.
Federal law treats this differently than a commercial business.
Okay.
And absent some different rules from the county, that kind of limits how it's treated.
I'd like to call the question on the amendment.
Is that in the debate? We have an amendment, motion by Justice Coger, second by Justice Hires. All those in favor? Those opposed? No. Amendment fails. Back to, we have the main motion on the table. We had a motion to pass by Justice Lyons and a second by Justice Rios Stafford. Any further discussion or debate on the main motion?
I think the motion is to send it back.
I'm sorry. You're correct. I'm sorry. I made a note here and even read over it. Referred it back to the planning board. Motion by Justice Lyons, second by Justice Rios Stafford. Mr. Allen, please call roll. I had misspoken and said that had made a motion to pass because but it's a motion to refer it back to the planning board. There is no public comment on that. Mr. Allen?
Justice Ecke? Yes. Justice Dean? Justice Washington? Yes. Justice Coger? Yes. Justice Dennis? Yes. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Bruns? Yes. Justice Wilson? Yes. Justice Massengill? Yes. Justice Rivera Lopez? Yes. Justice Lyons? Yes.
Item number 10 passes. Item number 11, Counselor, will you read that by title only?
An ordinance creating new planning and zoning law in Washington County and for other matters pertaining thereto.
Justice Lyons?
Thank you, Judge. Unfortunately, we have found some additional items we need to amend in this ordinance. I'm going to start with the first one, which is the real reason we need to amend this, and then because we're amending it, I've added some additional ones. So the first one is there are no approval procedures in this ordinance. In the current CUP, there is. In the ordinance we were debating to do zoning, it was there. When we ripped Section 5 out, it got ripped out. None of us noticed. So and everybody should have copies of this. So the second one down, page 14, Section 4, I'm proposing we add Section B, which is approval procedures, and I'm not going to read all these. There's several of them, which was pulled from the current ordinance, so these are all the same approval procedures you got to go through. There's several pages of them. And then, of course, renumber the rest of the sections appropriately.
I have a motion by Justice Lyons and a second by Justice Rios Stafford on the amendment that was handed out.
Judge, I'm sorry, one thing, just so everybody's know, again, transparency here, right, is J.P. Koger, thank you very much, ma'am, called me today and had pointed out there's a section in the original set I sent to you down about page 13K that has tutorial planning area narrative in it. And because of the state law, I pulled that out of the new version that I asked Mr. Sullivan to print for everybody. So just so you know, that's the change between those two copies.
Are you good, Justice Lyons, or
Sorry?
are you
Oh, I move that we amend to put Section B in.
for this? And then you're finished with the floor, or?
Oh, I've got, yeah, do you want to do them one at a time? How do you want to do them?
Yeah, I'd like to do them one at a time.
That's fine.
If that's okay with you
Yeah,
guys, just so we can.
that's what I thought. So
Okay.
that's fine. Go ahead.
Justice Ecke, do you want to comment? Justice Ecke?
I just like to know if Dr. Ada, I mean, we're supposed to make this less complicated, and it was to protect the process and to make it more concise.
So this is basically what we have right now in our condition, like in our ordinance, but
Yeah.
it was removed as JP Lyons mentioned. So basically this is 95% of our daily operations. That's what we do, like when we review plans, surveys, exemption, replats, and all of it, this is it.
Is this necessary, or is this in there already? Is this redundant?
No, it's not there, like it needs to go back.
It needs to go back.
It was removed like 2 months ago when everyone says like remove this from page this to page that.
Thank you for clarifying.
Yep.
So this does need to go back.
Absolutely. Yep.
Thank you.
Otherwise, like we will be sitting doing nothing, so.
Wow. What a job.
Justice Rios Stafford?
Thank you to Dr. Ada and also J.P. Lyons for surfacing this very important addition that we do need to put back in, since it sounds like it's 90% of the work that our Planning Commission does. My question, probably for Mr. Lester, if we amend this ordinance now, whether it's just this one or all three, will we have to again send this back to the Planning Commission to have a hearing again?
I don't believe so. I don't believe so.
Okay.
So the law's not super clear. And let me try to explain it the best way that I can make it make sense to me. When it comes to submitting an ordinance, a JP must basically submit the ordinance. In other words, the public can't come in and say, here's an ordinance for you to consider, without a JP actually taking that and submitting it. And that's kind of what the law says. However, there is really basically one little exception, and that's planning and zoning. And so there's a provision in the law that says a planning board can recommend to the quorum court or can give to the quorum court planning and zoning and say, vote on this. And then you get to debate it and vote on it. When the planning board initiates that, there is a set procedure that is followed whereby amendments that are made go back to the planning board. The planning board looks at those because if you make an amendment, it goes back for a public hearing to them. They can then recommend changes or accept what you've done and then send it back to you. You then have the ability to accept what they have, make changes, and then vote on it, right? It gives them the ability to initiate that. There's also a provision that talks about if it's initiated by the quorum court. And the law says that if a zoning change is initiated by the quorum court, you have to follow the public hearing procedures that the planning board does, which means it has to go for a public hearing. The quorum court can recommend changes, but you're not confined to that. You can then decide on that, you can modify it further, and then vote on it. So because of that, because it was initiated here, because you've had a public hearing on it already, and that happened at the last meeting, I don't think there was any confusion that that was a public hearing, then it's now back to you to look at what you have, modify, make changes, and then move forward with passing it.
Okay, all right, thank you. I did have one other comment, just to clarify for the public or people watching, the comment about the territorial jurisdictions. When we met last month, that was an amendment that I had brought forward to amend this, this entire proposed planning and zoning overhaul. And the reason is because in the Arkansas legislative session, this past legislative session, they voted to abolish territorial jurisdictions across Arkansas. And so I believe that law goes into effect at the beginning of August. And so my thought was that we needed to just go ahead and take everything out of this code to make it clean and to comply with state law and to avoid confusion. So what JP Lyons has done is that in this piece that we are adding back in, potentially if we vote in favor of this, which we should, that's my opinion, he has gone ahead and taken out the references to territorial jurisdictions in that piece of the code that we are sticking back in as well. And so thank you for that.
Just a second, I think we're still on the amendment, right? I hate to call that. Justice Massagill, I don't want to, there's a motion to call the question. I'm sorry. I'm trying to dictate how this is running. There's a motion to call the question. Is there a second? Second. Okay. Mr. Show of hands. Are we ready to call the question? Raise your hands. No.
This is only amendment, right?
This is only amendment. This is only on the amendment. To call the question. To call the question on the amendment. Show of hands. Who's in favor of calling the question for the amendment? For the amendment. That motion fails. Justice Massengill, you have the floor.
Yep. So I've only been on quorum court for a few months, but every time this comes in front of us, there's amendments, there's changes. I feel like we're doing the job of the Planning Commission. I watched the Planning Commission from May 1st, I believe, where they discussed this. They didn't vote on this. It doesn't look like these recommendations were fully vetted in the Planning Commission. So I just feel like when it comes to us, it ought to be a clean ordinance. I feel like we're trying to do the Planning Commission's job after the fact and not letting the process work the way it's supposed to. So.
Justice Coger?
Thank you, Judge. I would just like to point out that Arkansas Code 14-17-207 does say, in the event the court modifies the plan or parts of the plan, it shall return the plan as modified to the board, that's the planning board, for a public hearing on the modifications as provided. Thank you.
Councilor Lester?
You're correct. That's when the planning board initiates the change. That's not when the legislative body, you've got to understand, and it kind of goes to J.P. Massengill's, the planning board has the ability to bring about this legislative change, but that doesn't mean that they're the only ones that can. You are the legislative body. It has to come through you, and so there is also a provision to allow you, as the legislative body of the county, to move forward with changing legislation. And that's what you've done here. So this didn't initiate with them, therefore they don't get the ability to just go in and change. In other words, the planning board can't usurp your legislative authority, okay? And so when it comes to things where the planning board has initiated that and the quorum court comes in and modifies it, then you do have to send it back down, right? Because they had it and then you changed what they had, and so you send it back down for a public hearing to them. Here it was initiated by the quorum court and not the planning board. And so we have to have a public hearing because the law says that you shall hold at least one public meeting on the adoption or revision, and that planning and zoning recommendations initiated by the court shall be sent to the board for a public meeting as required, which you've done. So in my opinion, now that that's back to you, you've had your public hearing, and you can go ahead and move forward with this. Now, this body certainly is not prohibited by any means from sending it back for another public hearing. Okay, I'm not saying that. I'm not implying that at all. If that's what the body wants to do, to allow people to make comments on any changes you've made, you certainly can do that.
Justice Coger?
Thank you, Judge. Why would we not want to have a public hearing?
Wait, I'm gonna stop right here. We don't have a goal with this. Counselor Lester does not have a goal with this. Counselor Lester is here to give you his advice as a county attorney. You can agree with it or disagree with it. That's what we're saying. This is all up to you guys. His advice is that we don't have to have an additional one. And he's also said it's up to your pleasure to do whatever you would like. We're not taking a position on one way or the other.
I had a point of order.
Please.
Okay, thank you.
I was answering your question.
I would like to call a point of order concerning the chair. When a member has been assigned the floor and has begun to speak, unless he or she begins to discuss a subject when no motion is pending or speaks longer than the rules allow, he cannot be interrupted by another member or by the chair, except under very specific circumstances. So I ask that the chair rule that my point of order is well taken, and when the chair violates Robert's Rules of Order or principles of Robert's Rules, he is subject to a point of order call, a motion to censor, or even removal. I respectfully ask that the chair rule that my point is well taken.
I decline.
I appeal.
Back to the main motion.
I appeal.
Okay. That's, what's that vote? This is up to the vote of the body. What is your, Counselor?
So the members made a point of order, and the chair has ruled against the point of order. The member now has appealed that point of order to the body. The body now can vote to support the chair's decision and therefore support the point of order, or can vote to, I'm sorry, I'm getting that backwards. The body can vote yay to support the chair's decision, or nay to support the point of order. So a yes vote here would be to support the judge's decision. A no would be to support the member's decision.
Mr. Allen, let's call a roll.
Justice Ecke. Yay. Justice Dean. Yes. Justice Washington.
No.
No. Justice Coger.
No.
No. Justice Dennis. Yes. Justice Hires. Abstain. Justice Rios Stafford. Abstain. Justice Lemming. Yes. Justice Ricker. Yes. Justice Pond. Yes. Justice Bruns. No. Justice Wilson. Yes. Justice Massengill. No. Justice Rivera Lopez. No. Justice Lyons. Yes.
Sustained. back to the amendment. We're still debating the main amendment, or the first amendment for Justice Lyons. We had a motion to amend as written by Justice Lyons, a second by Rios Stafford. Are we ready for that question? Yes. All those in favor of the amendment, please show hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. That amendment passes. Justice Lyons?
Okay, second one I have, I'm submitting this because I perceive a contradiction in two sections of the ordinance. On page 56, section 5I, which is majority vote, it states, item 1, a conditional use may only be allowed upon a majority vote of the entire board membership and must be ratified by the quorum court, sitting in its legislative capacity by ordinance. Item 2, the planning administrator shall present allowed conditional use rulings to the quorum court for ratification at its next meeting following the meeting of the board. That's my motion to amend it to read that. What I'm taking out is the very last part of that, which states if in his or her opinion there is no likelihood of an appeal, however, ratification shall not be a bar to an appeal hearing set forth. I believe that causes confusion to section 5N, which on page 58 that states, no hearing before the quorum court shall be set until the full 30-day appeal period has ran. So I'm just trying to be consistent in the ordinance that we basically will not bring an allowed condition to the quorum court until after the 30-day appeal period where appeal could be made has run out. Again, one other note is I did add the word shall present allowed conditional use rulings. If you go back to the cup, it states that basically when the planning board votes to approve a cup, that's an allowed conditional use permit. Counselor, I'd like your opinion, but my stance is if it's approved, we need to ratify it. If it's denied, we don't need to ratify it. And why should we bring denied cups for ratification?
That's correct.
Okay, so that's the reason I put the allowed in there. We should only be bringing those that were approved to us for ratification. Let's not bring those that were already denied. Unless it's appealed by the process, then it comes to us as an appeal. So I make a motion that we make the change in reading.
I have a motion to amend by Justice Lyons. I think I heard second by Justice Rivera Lopez. Any further discussion? Yeah. Counselor would like to comment on this real quickly, if that's okay. Counselor?
This isn't intended to sway a vote, but I will let you know that there are sometimes the planning board meetings, just know this when you're voting, sometimes those planning board meetings will happen like, let's say, the week after quorum court, and the 30 days will run a few days after the next quorum court meeting. And there's a lot of times, I would say most projects, there is no indication of appeal, there's no objection. And so the purpose when the county passed that and made that change was to not hinder those projects in an undue delay. And so it was to say, hey, you can go ahead and approve this if there's no indication of appeal, the quorum court can go ahead and approve this. Now, the quorum court, in no circumstance can circumvent state law, and state law says that there is a 30-day appeal period. That's part of the state statute and court rules, is that you have, from an administrative decision, you have this appeal period, and so there's nothing that would hinder that. So even if you approve something and somebody comes in at the last minute and files an appeal, then that approval is halted because these people have a right. But the intent was to not hinder that. So I'm just letting you know the history of that.
Because this wasn't corrected legally.
Yeah, there's nothing illegally worded in how you've done this. No, not at all.
I think it's just confusion. So I think we either need to amend, as I did, or we need to amend to remove 5N personally, to do it one way or the other and not have both stated in there. Because like you said, state law says they get to appeal anyway.
Correct. I mean, there's nothing that says you can't do what you've done and take that early approval out and just say, nope, you've got to wait your 30 days, and if that means it's actually more closer to 60, then that's just the way it works.
And I try to argue with myself
Sure.
on that point, but again, it's being consistent in the ordinance and not causing confusion is my intent.
Justice Coger?
Yes, I would like to look at page 33 on the copy that's in our agenda tonight, where number 2, appeal procedures, and JP Lyons and I asked him about this today, and we talked about this, but there's a lot of concern in the community that this gives the judge the power to hear from, conditional uses.
Justice Lyons? Just a second, let me cue your microphone. Yes, sir.
I understand the point, we may want to discuss it, but that point has nothing to do with this amendment.
That's,
I'm not talking about the sections that describe appeal in this amendment, so I think it's not relevant to the amendment on the table, on the floor.
do you
I
agree?
didn't hear the last thing he said.
He said that what you're referencing, the section in the law, has nothing to do with his amendment. He says it's not germane to the discussion right now. Okay. Justice Rios Stafford?
Thank you, Judge. I just wanted to give my opinion that I'm in favor of this amendment as written, and the reason being is that I think it takes some of the subjectivity out of the code, because it takes out the section that says if in his or her opinion there is no likelihood of an appeal, and it makes everything cut and dry, the same for every applicant, and that way we're maybe not being accused of treating one applicant different from another. Maybe we're avoiding potential lawsuits for that reason. And so I think it just makes everything more uniform. So that's the reason I'm in favor of this as it is.
Gotcha. So I have a motion to amend by Justice Lyons and a second by Justice Rivera Lopez. All those in favor, show of hands. The amendment carries. Justice Lyons?
So the last one I have is going to be relevant to some of the discussions we've been having tonight, based on my view of why we are in this discrimination suit with Eagle Crest. So on page 3, it's section 1A46, we define a single-family residential. My amendment is to modify that to read a residential dwelling unit designed for or occupied by one family only, or up to 5 occupants that are not part of one family and being on a permanent foundation. So what I added was the up to 5 occupants that are not part of one family, and we've had a lot of that discussion tonight. I believe we're in this Eagle Crest lawsuit because we don't define that number. And I go back to a statement I said earlier. If we have 5 college students living in a house, they're not part of a family, we don't require them to go get a cup. And I think that's where they get us on, we require them to get a cup, which is different than everybody else, so we're discriminating against them, and they have a disability that says we shouldn't be. So I move that we amend this section to read as stated.
Can you restate that? Up to...
I have a motion to amend the definition of a single-family residence by Justice Lyons. I heard second by Justice Rivera Lopez. Further discussion? Justice Bruns?
Who's going to enforce this? I mean, how in the world do you enforce something like that? And then we're going to put ourselves in a bigger lawsuit down the road trying to enforce something that we don't even have anybody out here to enforce. You don't put a regulation on somebody to have somebody go out and do an action and not be able to enforce it. That's ridiculous.
No, may I respond?
Yes, sir.
Agree. The enforcement of cups is based on constituents bringing that somebody is not following the ordinance, is the way enforcement works today. And I figure that's going to be the same way. Let's take Eagle Crest as an example. Let's take
Who's going to enforce it?
Wait a minute. We can't argue back and forth. He has the floor right now. I've let him respond. Just give him just a second, Justice Bruns.
So again, let me explain how I think it gets us out of the Eagle Crest. There was, actually the complaint with Eagle Crest started with they didn't have a cup at all. We went through the process, as Counselor said, it was back and forth, you need it, don't need a cup. We went out and looked at it and said, oh no, you do need a cup. So in that situation, we go out, we look at it, we're like, oh, you're gonna have 20 or so people here, and in residential, you're more than 5, you do need a cup. Now we're on clear ground to say, you do need a cup, and you need to go through the process, and we're treating everybody fairly. That's the real point. Not that we're gonna have anybody running around checking houses to see how many people that are not family.
Ain't nobody
That's
said
not
Wait a
gonna
minute.
happen.
Okay. Justice Bruns?
Nobody
floor, sir.
said that, Justice Lyon. I'm just gonna tell you that. I asked simply, who's gonna enforce it if we pass a rule? There is nobody out here to enforce it. Are you, as a JP, gonna go enforce it?
Let's leave our comments to the chair, so we don't have it so confrontational. Justice Bruns?
Who's gonna enforce it?
Are you asking me?
Well, you told me to address you.
Right, I mean, it's not my amendment, but we have to keep things non-confrontational between you guys.
You want me to address you, I'll address you. Who's gonna enforce it?
I don't have an answer for that.
Because there is nobody. Okay? And so we're gonna pass a legislation that we have nobody to enforce, and we're gonna end up getting ourselves, I mean, we got people in my district that call me daily and tell me that they call your office daily and don't even get return phone calls because they want to complain about things.
Justice Ecke, will you cue your mic? Ladies and gentlemen, we cannot have outbursts from the crowd.
Please.
And if it continues, I'm going to have to ask people to spend their time somewhere else this evening. Justice
I call a
Ecke?
point of order. His discussion is not germane to this amendment. So
Agreed.
whatever comments that are being made are not germane. Point of order.
Justice Massengill?
Yeah, I was gonna ask JP Lyons to restate, because I've got something written here, and I think you modified it, right?
It should have been what was in your pack, what was late.
Okay. Okay. Yeah, this is different, so thanks. That's all I need.
Justice Rio Stafford?
Thank you, Judge. So there's another piece of paper you all have that's titled Single Family Defined by Occupancy. And that is my proposal to amend this amendment. I don't know if it's going to be a friendly amendment or not. That's up to JP Lyons. But I used to serve on the Fayetteville Housing Authority. The U.S. Department of Housing and Urban Development defines things by occupancy, 2 occupants for every 1 bedroom. And so the reason that I want to slightly modify this amendment by JP Lyons, his says up to 5 occupants that are not part of one family. I'd like to amend that instead to say a residential dwelling unit designed for or occupied by 1 family only, or up to 2 unrelated occupants per every 1 bedroom and being on a permanent foundation. The reason being is that the houses in our county can be of all different shapes and sizes. If you have a small 1-bedroom house, you know, I don't want us to be saying that we can have 5 unrelated people in a 1-bedroom house. That's, you know, overcrowding. On the other side, it could be a 5-bedroom house. And, you know, there may be a reason, you know, we want to give freedom and liberty to the property owners to be able to, you know, do what they want within reasonable bounds. And, you know, I think two people per 1 bedroom gives a little bit more flexibility, you know, to different sizes of homes. And so I move to amend the amendment.
I have a motion to amend. You don't consider that a friendly amendment? Do you consider it friendly? You consider it friendly, and Justice Rivera Lopez, your second still stands? Do you, okay, well, good. So, any further discussion on that amendment now? The amended amendment. Justice Lemming.
I don't know how to say this, but when I growed up, we had a 2-bedroom home. There was 5 of us kids and mom and dad. And we had 1 bathtub. And we lived that way for years, and we come out pretty good. There's a lot of you folks around this horseshoe needs to get out and get into the urban, rural areas of Washington County. And you're going to find a lot of families. We just had a big fire in Goshen, and there was 16 family members living in that home. People can't afford these $1 million homes, and they can't afford these apartments for $1,200, $1,500 a month. You get out in the rural areas, you're going to find them living in the end of a chicken house. You're going to find them living in campers. You're going to find them living wherever they can live and live happily. And they love to be there, and they don't want you out there telling them what the hell to do. They want you to be left alone. We do not need to sit here and make these crazy-ass rules that don't help folks. This world is in an uproar and a mess as it is. And just like Mr. Burns says, we have no way to police all this stuff. And I've been arguing this ever since we've been working on this new zoning. If you don't have a fire marshal, you're putting this on the back of these volunteer firemen to be the fire marshals in these rural areas, it ain't gonna work. They don't get paid, they're volunteer, a lot of them. And then when you call the state of Arkansas's fire marshal, just like we had a big deal out here on some gas in the guy's big building he built, they laughed at us. We gotta have help. If you're gonna make all this crud, these rules, we gotta have help to enforce it. The planning director, if he could, he would tell you, you need enforcement. So there's no sense in making all this stuff if you cannot enforce the rules that you're trying to pass. And we need to leave people alone, let them live where they wanna live and however they wanna live. Yes, if there's kids in danger and those are running water and they're doing crazy things, that's a different animal. But if they're living happy, leave them alone. Thank you.
Justice Lyons?
Thank you. And I think my colleague's comments is exactly why the words are in there regarding family and related and not related, because we agree with you. Your family on a farm have a lot of kids, work the farm, et cetera. This doesn't restrict that. If you're a family and you're living together, you got 3 bedrooms and 20 people, this has no effect whatsoever. This is simply trying to keep us out of discrimination lawsuits by organizations that want to run a commercial enterprise in a single-family residential area that they probably shouldn't be in, and we should require them to have a cup. So that, just for clarity. Thank you.
Justice Massengill?
Yeah, I was just gonna say, I mean, this is just a definition. What's a definition of a single-family home? And that's what this amendment changes, so just want to state.
Justice Lemming, final word?
I just want to make one more comment about it, because I know a lot of families that has been drug addicted, that has got alcohol problems. They do not live with their parents. They're living with friends that's taking care of them and helping them get through all this. And here you're going to tell them that you're not family, you can't live here with these folks. That, you need to get out in the rural area and see. You live sort of in the rural area, but you go down where I live and you'll see a lot of that. There's a lot of families that's helping other families' kids because they can't get along with one another. And it's hard for me to sit here and say, well, that family wants to help them, and it's none of our business to allow them to help them, but hey, you can't sleep in that house because there's too many people there. We can't do that. Thank you.
Justice Rio Stafford?
So I just want to point out, I agree with all that, and I agree that people should be able to do that, and we should not interfere in how people are living. But I wanted to point out that under our current ordinance, the way that it is defined right now is that a single-family home is designated for one family only, which means under our current ordinance, it's technically anybody who's not related to the family shouldn't be living there. And so I think that's a problem with our current ordinances. You know, so I think what we're doing is trying to open that up. Thank you.
Justice Rivera Lopez?
Yeah, similarly to Rio Stafford, I think, and even what JP Lyon has expressed, this is a matter of having recourse in situations like Eagle Crest. It's not so that we are out policing how people live. It is that so when someone in the community has a legitimate concern about how properties are being used that they are, affected by, that they would have some form of legal recourse because it is not being used as a single-family home. I don't think anyone is approaching this with the idea that everyone is now going to be deputized to say, oh, this person lives here and they shouldn't live here. It's for legitimate concerns about when a property is being used in a fashion that is inconsistent with how all the other ones are used. And we do not have a recourse at this moment, as we've expressed in the Eagle Crest situation, and that's what this is looking to address. It's not looking to tell somebody how and why they can live with who or any of that, I don't believe. Thank you, Chair.
Justice Zeki?
Thank you, Judge. I believe the difference between Eagle Crest and let's just say the college kids that are living all together in one house. The difference is one's a commercial enterprise. They're for-profit business, whereas the college kids are just renting a house, trying to get to school. They are not, it's not a business. So that's the difference, and that's why Eagle Crest was requested or required to get a CUP, because they are a commercial enterprise and they are a nationwide company. Thank you.
Justice Hires?
Thank you, Judge. I would love to agree with you because I have some neighbors who their landlord rents to for frat boys, and they drive me insane. And so I think that under that definition, the landlord is also a commercial business. So maybe my landlord next door should get a CUP. They actually have an LLC. I want to go back and just real quick go to the actual definition that JP Rio Stafford was reading to us a moment ago. The current ordinance, page 3, on your on the definitions that we just added back in. Number 46, which is what JP Rio Stafford's amendment deals with. It says dwelling single family, a residential dwelling unit designed for or are occupied by one family only and being on a permanent foundation. So that's what we've got in here now. What Rio Stafford is amending, it would say a residential dwelling unit designed for or are occupied by one family or 2 unrelated occupants per every 1 bedroom and being on a permanent foundation. We're just broadening what's already in there. So, thank you.
All right, are we ready for amendment number 3? Keep in mind this accepted a friendly amendment. This is amendment to amend the definition of a single-family residence, motioned by Justice Lyons, seconded by Justice Rivera Lopez. Show of hands, who to pass or to implement item number 3? 1, 2, 3, 4, 5, 6, 7, 8. Amendment passes. Amendment carries. Justice Coger?
Yes, thank you, Judge. I have an amendment to make. If the court will go to page 33, it's on the copy that's on our agenda tonight. And for those people at home, it's on page 57 of the online version. My amendment would be under item 2, appeal procedures, and A1, A little I. At the end of that paragraph, which is just there right now, I would add this. The appeal process for land development in the unincorporated areas of Washington County, such as conditional uses, appears under N, large N, parentheses, appeals from board, and shall be appealed first to the Quorum Court as set out in...
Just a second, Justice Coger. Point of order, Justice Rio Stafford.
Justice Coger, I appreciate this. Could you give us a second to get to the right page? Could you just state again what page that is?
I'm sorry.
Could you restate the
the page-
reference
the
so that
page
they can
number.
It's
find
on
it?
page 33, and, I'm sorry, 33, paragraph 2, appeal procedures, A, and then it's little I, and I would just add what I want, my amendment would add on to the end of that paragraph, which as it exists right now, I'd be adding on to that, after the word decision, period, and then my amendment. I'm sorry. Okay, my amendment, so we read it, my amendment now? Okay. This is my amendment, and I'm sorry I didn't give you time to get there. After the word decision, my amendment would read, the appeal process of land development in the unincorporated areas of Washington County, such as conditional uses, appears under large N parentheses, appeals from board, and shall be appealed first to the quorum court as set out in N parentheses, 1 parentheses, period. And the reason I'm doing that, colleagues, is because there has been a lot of confusion. There's a lot of concern and questions about that one paragraph. So if we could just make it clear, and I'm open if someone else has a shorter amendment to that, I'd welcome that friendly amendment. But that's why I'm bringing this, because I want it to be very clear to everybody what we mean by this. Thank you.
So this is inside of.
Just a second. Can you, you got your mic queued, I'm sorry. Go ahead, Justice Lyons. I needed to do it. I need to catch up.
You're just making us feel better who sit there on other days of the week.
That's so true.
So I think this is section 4. So this is section 4C 2AI, correct? Okay. So reminder, section 4 deals with design standards and those types of items. As such, those design standards are technical standards that are listed, and the planning board decides that based on those standards that applicants must apply to them, et cetera. I think we amended this last time, and I added words to indicate that this process is for decisions made under this section 4. Again, for the same reason, trying to clear up this versus the appeal process that's down in section 5 that deals with the CUP process and the zoning that comes to us, right? So with that, can you repeat your amended words? I'm sorry. Can you repeat your amended words? So at the end of I, decision period, and then your new text.
Okay, my amendment is on page 33, and under paragraph that says appeal procedures, and then there's an A, planning board of directors, and then a little I. So my amendment would come after that, the word decision as it appears right now on the agenda, and on the copy that's on the agenda. And it would read, the appeal process for land development in the unincorporated areas of Washington County, Arkansas, such as conditional uses, appears under N, appeals from board, and shall be appealed first to the quorum court as set out in N1.
So really all you're trying to do is add there a referral to the section in section 5 that dictates appeals from a zoning point of view on the vote of the CUPs come to the quorum court.
I'm sorry, JP Lyons, I did not hear all of that, but yes, what I'm trying to do is make sure that that everybody understands that appeals from the planning board, like in section 5, for for conditional uses, those go to the quorum court. We know that. But I just want to make this section clear that this part of the appeal process, just so that doesn't apply to that, so that, I don't know, so that everybody can be clear on that.
No, I'm with you.
Thank you.
I'm with you. Is there, I'm trying to think of a better way to word that to make it not as confusing. I understand what you're trying to get to, but I think when some of the words we put in there starts making it confusing. Maybe it's just me. I don't know.
Well, first off, you're not referencing it properly, because there is no section N under section 4. And so when you say see section N, there is no section N under section 4.
It should,
It's under subsection 5, subsection N. And, you know, I think that personally, in reading this, it says the following appeal procedures have been established for decisions regarding the standards identified in section 4 of this ordinance, and then has a semicolon, right? Or a colon.
That's page 33.
yeah. it has-
Page
Well,
33.
C, section C, subsection 2, appeal procedures. Right. It references that the decisions regarding the standards identified in section 4 of this ordinance, and then lays out the appeal procedure for appealing the decisions in section 4. It's clear that that only applies to section 4. But my point is, if you're going to make an amendment, it needs to not be under subsection N. You need to also state that that's under 5N, because there is no N in section 4. So what you would do would actually be more confusing, because there is no N. Does that make sense?
Yes, and maybe let me make an amendment to my amendment. May I do that? No?
Or just withdraw your amendment and make
No,
a
I'm not
new-
withdrawing it.
Okay.
Okay.
We need a main motion for this item.
We have a motion.
We
to-
have a,
motion to amend.
I'm sorry, motion to
There's been no
amend.
second.
Do we have a second? I thought she
No,
was,
she said she's not withdrawing.
you're not withdrawing. Okay, I'm sorry, I misunderstood you. She makes a motion, do we have a second? Dies for the lack of second. Back to the, all right. Have a motion by Justice Koger and a second by Justice Rios Stafford. Further discussion on the amendment. Any further discussion? Justice Rios Stafford?
I'm going to suggest something that may be a friendly amendment or not to truly simplify this. I think I understand what you're trying to do, which is just put a reference in here that this has nothing to do with the CUP process and that that's in another part of the ordinance. And so my friendly amendment would just to, we're on page 33, if everybody has your page 33 up, where we say number 2, appeal procedures. The following appeal procedures have been established for decisions regarding the standards identified in section 4 of this ordinance. And we make that a period. And then we say, for appeals of CUPs, please see section 5, period. That's it. 5N, section 5N. For appeals of CUPs, please see section 5N.
First off, wait a minute, I gotta work through this parliamentarily now. Justice Koger, do you accept that as a friendly amendment? Okay. Justice Koger?
Yes. I do accept that friendly amendment, but could you just read it one more time?
Sure.
Just make sure I've got it all.
Sure. At the start of section 2, where it says appeal procedures, and you have that sentence there, the following appeal procedures have been established for decisions regarding the standards identified in section 4 of this ordinance, in that with a period, and then add a sentence that says, for appeals of CUPs, please see section 5N.
Okay.
That's it.
I agree to that, but I just as a matter to point out, I think you said conditional use permits, and we're not saying that in this ordinance. We're saying conditional uses. That's just a technical matter. I don't know if that matters or not.
Sure.
So-
Yeah, I'm fine with that.
All right, so you accepted that as a friendly amendment, and of course, I'm assuming your second still stands?
Yes.
Okay, any further discussion on that amendment? Okay, I'm sorry. Just, Counselor Lester, sorry.
This is kind of the problem with friendly amendments. Your amendment doesn't take away anything she just wrote. So so the proper thing to do would be to separate, these are actually 2 amendments, and so we'd need to vote on her amendment, because yours would not be proper right now. And then if it's voted down, then your amendment we could reinstate.
Clear as mud? So I accept yours as a motion to amend. Do we have a second for Justice Rios Stafford's amendment? Second, Justice Dean. First
Hold
of
on,
all,
is the motion to amend to remove the language from J.P. Koger? Yes. Okay. So the motion on the floor is a motion to amend. The amendment is to amend J.P. Koger's ordinance by completely striking what she said and inserting, for appeals of CUPs, please see section 5N as stated by Justice Stafford. That's the motion on the floor.
show of hands for the amendment. Amendment carries. We still need to take up Justice Koger's amendment. We had motion and second by Justice Rios Stafford. A show of hands for who favors that amendment.
Wait a minute. But that is the main so the main motion is, this is why I'm saying we should have done it in two separate motions. Now the main motion is basically exactly what we've done, but you've still got to vote on the main motion. Now you're voting to pass the amended amendment, which is striking through what Justice Koger said and applying what Justice Stafford said. So it's basically the same thing. This is why Roberts does not, just so y'all know, there is no such thing as a friendly amendment under Roberts rules. We don't do that, okay?
So now we have motion and second, show of hands to pass the amended amendment. Okay, that carries. Justice Lyons.
Okay, so I think the last order, Counselor, is we need to decide whether we're going to vote on this or send it back to planning, and either is appropriate.
I would say,
per law.
I would say either is appropriate. I would say consider that you've made a lot of changes, and that my advice would probably be to send it back for another public hearing, just to get that out of the way and not have that as a challenge at some point.
Okay. I move we refer this back to the planning board for a special meeting.
I have a motion to refer to the planning board for a special meeting by Justice Lyons, second by Justice Dean. Any more? Any other discussion? Justice Koger.
Yes, thank you, Judge. I heard what Attorney Lester said earlier about a public meeting, but I think because this ordinance is so vast and covers so much and will affect the future of Washington County for decades to come, that I would like to move that we have the public meeting will be at the planning board. It will be conducted by the planning board, but Attorney Lester and Dr. Ada will be there to answer questions from the public, because the public, our taxpayers, the citizens of Washington County, deserve to ask their questions to their elected officials, and they deserve to get answers.
I'm not an elected official.
Neither is Dr. Ada.
Okay, wait a minute, guys. We have a motion to refer this to the planning board by Justice Lyons, second by Justice Dean. You're making a motion. Is that correct? Correct. What is your motion? Please be very specific with the wording, because we're going to have to jot it down. Justice Koger?
I move that the Planning Commission public hearing on this ordinance that we're discussing right now will include a question and answer period, allowing the public to speak, to voice their concerns, and to get answers to their questions from their elected officials.
Counselor Lester?
So the main motion was to refer this as amended to the planning board for a public hearing. And then there was a motion to amend the main motion to include that the public hearing include a question and answer session to get answers from the elected officials, from their elected officials. The amendment, the amendment's first, right.
So we have motion. Do we have second for Justice Koger's amendment? Dies for lack of second. Now back to the main motion. We have a motion to refer to the planning board by Justice. Justice, I'm sorry, I got the wrong one. Justice Rivera Lopez?
To clarify, it's, Ada isn't elected, that wouldn't make sense, right? So it would. I don't think this is in the spirit of what you wanted, Justice Koger, because I don't believe either one of those people would be required, and you named them prior.
So that died for lack of a second. We're back to the, Justice Lyons made a motion to refer to the planning board, seconded by Justice Dean. Further discussion on that motion. Justice Massengill, I'm sorry I cued your mic. Do you have any?
Well, I want to make a motion, but can I wait till after we vote?
Yes,
on
sir.
this? Okay.
Justice Rio Stafford.
Just a clarification, are we back on the main motion?
Back to the main motion made by Justice Lyons to refer the planning ordinance back to the planning board for the public hearing, seconded by Justice Dean.
Great, thank you.
That's what we're going to vote on.
Perfect. I'm in favor of this. You know, even though we're not required to do it, we've made so many changes tonight that I think it just behooves us to present the public with a clean copy of this with all these changes that we've made, even though I'm reluctant to push this off for another month. But I think that we need to do it. And so I hope that I'll be there. I've put this in my calendar of when our next planning board meeting is. And if people have any questions for me or your JP or anybody, email me, text me, call me. Happy to talk to you or help get your questions answered. Thanks.
Justice Dennis?
I wasn't sure if we were going to have time to speak after we vote or not. We've gone a long way from the way we do procedures, I think. This should have all been taken care of in committee meetings. And I kind of resent the fact that I see people with written copies of things all written out, and they have copies. I don't have the copy to read it, and yet we bring it up and say, oh, this is what I'm saying. Well, you know, it'd be nice to know in advance where I could read it and see what they're going to read to me. I don't like surprises, and I like being included, and I don't like that the court looks like it's got people that know everything they're talking about before they get here, like we've had meetings or we've had conversations or we're texting. If we're going to do that, include everybody so that at least I can read and see what's going to happen tonight. But I don't like these surprises, and that's just kind of why I've not been voting, because I think a lot of things have been done wrong on it. So thank you.
Justice Lyons?
Thank you. No disrespect, but I personally sent out a packet Wednesday. JP Koger, you called me today about some questions on it. Was it Wednesday I sent that out? And it was everything I was talking about here. JP.
Order, we're voting on the main motion.
Yeah, she's right.
Are we ready to take the question to refer this to the planning board? Mr. Allen, will you please call a roll on that?
Justice Ecke? Yes. Justice Dean? Yes. Justice Washington? Yes. Justice Koger? Yes. Justice Dennis? Abstain. Justice Hires? Yes. Justice Rio Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Bruns? Yes. Justice Wilson? Yes. Justice Massengill? Yes. Justice Rivera Lopez? Yes. Justice Lyons? Yes.